Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're looking into my litigation bag, or my redwell. This is what attorneys bring to court if they have a trial or a motion. So let's see what's in here. So number one is you're gonna have a folder, and you're gonna have a folder known as your pleadings. And what that basically means is that you have your lawsuit in there. When you file a lawsuit, it's known as a summons and verified complaint. And you're also going to have an answer from each of the defendants, and that's their appearance when they appear in the case. You're also going to have what's known as an affidavit of service, which is the process server that you use going to the defendant's place of business or their home and actually serving them with the lawsuit, and then writing down like their age, their height, and the fact that they were in fact served. You're also going to have, in New York at least, what's known as a bill of particulars. And what that means is that after they appear, the defendants get a chance to ask you questions. And the questions could be things like, where did your accident happen? How did your accident happen, or your injury? What did we do wrong? What is our negligence? And what injuries are you claiming? And then the plaintiff's attorney has to respond to these questions in what's known as a bill of particulars. And it is what it sounds like, right? You give details, or you particularize what's in the complaint, because the complaint is more general, but here you're going to be specific. You're going to say my client had a fracture of the left leg, or my client had surgery at L5S1 known as a spinal fusion, and you're going to mimic the words from the operative report or from the x-ray, right? And you need to have all that in there, because if you don't have something in a bill of particulars, then the judge could say, well, now you can't claim that at trial. You're precluded, meaning you can't bring that evidence in. So you have to be very careful and make sure you list all the injuries, or if you don't know the injuries yet at the beginning, you could supplement or amend the bill of particulars later on. The other thing that goes into pleading is known as a note of issue, and that just means that everything is done and you're ready to place the case on the trial calendar. Now, the next folder that you have in cases is a folder known as discovery. And discovery is basically document discovery, such as one of the parties, either the plaintiff or the defendant, asking for certain documents. As a plaintiff, we might ask for incident reports or photographs of the damage to a car. If it's a trip and fall, we might ask for maintenance records or inspection records or prior repair records, right? Or just photos or videos of the actual event, the actual fall or the actual car crash. The defendant usually will ask for medical records, authorizations, or copies of medical records, and that's document discovery. The other type of discovery you have is something known as depositions or examinations before trial, and that's basically where you answer questions that the other lawyer asks you. So as a plaintiff, they're going to ask you, hey, how did you get hurt, and what are your injuries? And when we question the defendants, depending on the type of case, if it's a car crash, we're going to ask them how they were unsafe or what did they do to cause the crash. And if it's a trip and fall, we're going to also ask them about their prior inspections and safety practices to prove that they were at fault for example, the hole or the unsafe condition that our client tripped in. Up next is a folder known as medicals, and medicals are basically all your medical records as an injury victim. So that could include the hospital, the emergency, ambulance call report and emergency technicians that bring you to the hospital. It could also include the hospital records, the physical therapy records, your surgeon's records, treating physicians like neurologists, orthopedics, or whoever you've seen, whatever medical care you have had. So if a case is more complex and somebody's getting a lot of treatment, we'll actually have folders for each doctor, and each provider will be its own separate folder. And medical records really includes the medical records themselves, as well as requests for medical records. That's when we send a cover letter along with a HIPAA authorization, attempting to obtain the medical records from the various providers, right, the various doctors. And then you'll also have a medical timeline of all the treatment. And I think that's very important, because especially when you get to trial, you want to be able to show, here's a timeline of all the treatment, and you make a nice 3D timeline or graphic timeline to show the jury. The next folder is going to be something known as IME reports. Now, those are known as independent medical exams, but they're not really independent. These are the insurance company's doctors or the defense attorney's doctors that are going to see the plaintiff on behalf of the defendants and write a report saying that the plaintiff either is not hurt or that the plaintiff is hurt, but the injury is not caused by the traumatic event like the car crash or the fall, but rather it's caused by degenerative changes such as living your life, the normal painless aging process that we all go through. So you have to be able to, read those reports carefully, know how to cross-examine those doctors. And what we love to do is when our clients go to these, we call them DMEs, defense medical examiners. When our clients go to these DMEs, we send a watchdog, and the watchdog sits there and actually writes down everything that the doctor does. Or in some states, it's permissible to videotape or audio tape these DMEs. And that's very crucial because later on, the doctor can testify, I did a 30-minute comprehensive exam, but wait a minute, the watchdog was there. It's an independent person that was watching everything you did, and it calculated the start time of the exam and the stop time. And it wasn't 30 minutes, it was like 2 minutes. That's usually what happens. You have to be very, very careful with that. The next folder we have is about invoices, right? And invoices could be a wide variety of things. There could be liens. For example, a doctor's treating you for free, but then when you win your case and you get a big amount, the doctor wants payback for his or her services, the cost of the medical. You could also have receipts for filing a lawsuit. Filing a lawsuit in Supreme Court is $210. After the defendant appears, you need to ask that a judge get assigned. That's known as an RJI, or request for judicial intervention. That costs $95. So all your receipts, all your bills, all your invoices. The other subpart, or you could keep it in a separate folder along with invoices, is funding. Sometimes people need money now. They can't wait for their case to be over, so they get lawsuit funding, and you want to have all the contracts and know what the payoffs are. So there could be liens for Medicaid, Medicare, there could be liens for doctors, and there could also be liens for these funding companies if a client has borrowed money against their lawsuit. The next folder that's very important is just the court orders. So when you start a litigation, you're going to have the scheduling order, that's the preliminary conference, and you're going to have compliance conferences. So the preliminary conference just basically tells you when you have to give documents to the other side, when you're going to have a deposition and other deadlines. And then the compliance conference basically seeks to make sure that you complied with the original scheduling order. And if you're not able to comply, the judge can then give you a little bit more time and you explain why you need more time. But those are all the court orders. Court orders could also be in response to motions. For example, we could make a motion for summary judgment, meaning there's no question to be decided by a jury, but rather, as a matter of law, we should win on liability. And the defendant can make a motion for summary judgment, or any motion, right? A motion is just when you ask a judge to do something. It could be anything. It could be to change venue from one county to another county. It could be to dismiss the case. It could be to grant an adjournment. It could be to compel a deposition or compel responses to discovery that you haven't received. So all the court orders as to the motions go in the folder, as well as court orders from any of these scheduling conferences or compliance conferences. Now the next folder is actually the motions folder. So the folder we just talked about was called court orders. So that'll just have the court order, but you also need a folder for the actual motion. So when you file a motion, you'll file the motion, the notice of motion. It'll say what relief you're seeking. And you'll also have an affirmation in support. Now, when you do that, the other side can then file an affirmation in opposition, right? And then you need to have all that. And then there'll be exhibits, like for example, the lawsuit. It could be documentary evidence or photographs or affidavits or whatever, what have you. But you need to have a motions folder. One of the final folders is going to be a folder called depositions. And there you're going to have the deposition transcripts when the other side questions your client, as well as when you question the other side's witnesses. And remember, you can have depositions as to non-party witnesses too, that are just witnesses that are involved somehow, either liability or damages, but are not a party to the lawsuits. You could have those depositions. I like to videotape depositions so you could actually play them to the jury. That's very good, especially in this day and age when everybody's watching videos on their phones. But a lot of the times you'll have that, and you'll also always have a transcript, a written transcript of the deposition. And then the very, very final folder is just a simple folder called notes. And that is just more like tasks, notes, You know, it could be summaries of the deposition. Sometimes the deposition could be like 1,000 pages. So you want to have a 2-3 page summary. And it might be like court reports when an attorney goes to court and they argue a motion or they do an important hearing in a case. They might just, you know, want to have a summary of what happened. So you have all those notes and summaries, and that's basically, you know, most of it. The other folders you might want to have is a folder for photographs, where you have all the photographs in a case, like the accident, the plaintiff's injuries, and then you might want to have a final folder with the client's name, just like John Smith. You have the intake when you did the initial questionnaire, and any notes or anything important there. So I hope this was helpful, but this is basically what goes into a redwell, and this is what you bring to court with you when you go to trial or you go to an important hearing. Now, these days, you know, a lot of lawyers are not doing it old school like this, but they're actually bringing like an iPad or a laptop and they're keeping it organized that way, but it's still organized in the same idea of all these different categories that we mentioned. So I hope this was helpful, and let us know what questions you have. Thank you so much.